Karen Reed case is over with. It's moot. It's gone. Okay.
As we all know, I think that it's important that the discovery be turned over.
You think? I think it's important for you to do your job, sir. Is Brado saying that Turtleboy had property confiscated from him that is in possession of very embarrassing material for the government?
Specifically, messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss.
You must follow the law. The law says glorious. Is it a lawsuit? Probably. Why not? Well, hello everybody, and welcome back to Buckle Up, It's the Law with attorney Larry Forman. Folks, today we are going to continue the saga of Turtleboy and his case in Massachusetts. As you know, Turtleboy has had a jury trial the other week, and he won. He beat the government on one of his cases, but the bigger case, the witness intimidation charges case, is still moving forward. And from what I hear, it is phenomenal. Especially we get to see Mark Betterow, Bradel, all working together to try and get Turtleboy freedom. So, without further ado, let's watch the hearing from yesterday, July 8th, 2025. Let's go.
Good afternoon, Your Honor. Robert Cosgrove from Pelham.
Good afternoon.
Hello, Your Honor. Timothy Bradel on behalf of Aiden Carney. To my left.
Good afternoon, Mr. Kern.
And Mark Meadow, Mr. Klein.
Hi, Mr. Barrow. Good afternoon. Okay, let's arraign him on a new case.
The Karen Reed case is over with. It's moot. It's gone. Okay. And my filing judge entitled Aiden Carney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it. But I was asking to just release everything from impoundment, Your Honor.
Okay, so what does that mean? His defense attorney, Bradel, is asking for Turtleboy's property to be released back to him. Whatever property they confiscated from him at the time of his arrest, it's called impoundment. So to release whatever Turtleboy's property is back to him from impoundment by the government.
The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason.
Wait a minute. Is Bradel saying that Turtleboy had property confiscated from him that is in possession of very embarrassing material for the government? Like to put the government in a bad light, and so the government's like, okay, we're gonna hold on to this so you can't release it because we have it. Is this for real?
Reason to release documents. And that's really all the Commonwealth has left on the existing stuff is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause election shifts, and that's not a reason to impound things, Your Honor.
I agree.
Initially, we have sort of taken the candy from, from the Commonwealth, and when they say, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor. This is a case of immense public interest. This is a case of, First Amendment issues, and I know we may disagree on that, but...
By the way, I see Kelly Reed right there in the back, right by the window, the lady. That's Kelly Reed, Karen Reed's sister-in-law. She's married to Nathan. Really good woman. I'm not surprised that she's in the courtroom supporting Aiden. This is awesome. This is really good.
That's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with it, so that's okay. And, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and these text messages about and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things.
Yeah.
So we're not asking to publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other. And the content of them per se has no persuasive power to make you want to impound.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a
Yeah, I'd give you that. Was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradle, Mr. Betterow.
Okay, so they filed a motion to release Aiden's stuff, and it was filed literally the morning of right before this hearing. The prosecutor, for better or for worse, they're asking for some time to respond. That's not abnormal. I mean, you see Aiden kind of rolling his eyes because he's like, oh, come on, you need more than a week. You know, Aiden's case is not the only case on the docket. The prosecutor has other cases on the docket, obviously. I'm not trying to defend the prosecutor here. I understand Aiden's frustration. He wants the stuff. Give me the stuff. I mean, 2 weeks is not unreasonable, okay? They're not asking for 2 years. They're not asking for 2 months. 2 weeks. The judge is also, you can tell, the judge is a little on edge. He's like, Mr. Cosgrove, that's the prosecutor. Get on it, okay? You received this motion. Okay, you need some time. I'll give you a week. You need 2? Okay, I'll give you 2. You see what I mean? So it's a very hairy and sticky situation, but that issue seems to be addressed fairly well. So now let's see what else we've got, because I know there's more. I know there's so much more.
You absolutely have every opportunity.
Thank you very much,
Okay.
Your Honor.
Now, Your Honor, with respect to the items that I was going to turn over today,
So I'll allow the motion. Mr. Bradle, I'm up here.
Sorry, Your Honor.
Betterow does not look happy.
Sorry.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Betterow. My point is this: if you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine. So,
Please note our
I like this judge.
yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very much.
Does that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off, I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
Yeah.
you know, I think we're going to agree to go in person with our people and figure it out. So
Yeah, sure.
that's the first thing I want to say. But then, in addition, Your Honor, there's the this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our Third Motion to Compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time. But, you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
can you give me an extra week? Or
An extra week.
Thank you.
All right. But it is, Mr. Bradle makes a very good point. As we all know, I think that it's important that the discovery be turned over.
You think? I think it's important for you to do your job, sir. To turn over the stuff that you were supposed to turn over months ago. Oh, I hate prosecutors sometimes.
Bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradle has some complaints, and some of them may well be legitimate, there has been a substantial amount.
Some of them may be legitimate, he says.
Yeah.
Turned over in this case.
Yeah.
Wow.
If you turn it over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay,
Wow.
great.
Thank you. And Attorney Better has a number of items as well.
Mr. Betterow.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment. Specifically, messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware,
Oh, so the motion for the lifting of the impoundment goes way beyond election and whatnot. It may have material that will materially impact this case and the defense's request to have the prosecution dismiss or the court dismiss this case with prejudice. Oh, I want to hear this.
Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Carney's interest and ultimately, on some level, his indictment in this case. But also...
on some level? How about on every level, Mark? You and I both know you just can't say it in open court, but yes, 100%.
Messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct.
Called out.
Messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages
Jennifer McCabe?
should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded this time.
Okay. Anything you want to say to that, Mr. President?
Wow.
Not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other.
I think that makes sense.
I won't ask for another week. I won't ask for another day.
Oh my God, Cosgrove looks so defeated. He knows he's on the losing end of this stick. I feel no remorse. You picked this case to prosecute. You're gonna have to deal with the fallout, bud.
Why don't I do this? Why don't you all come up this side? Let me take a look. Mr. Betterow, the floor is yours. What else
Thank
you
you.
got?
Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness, and we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain.
Holy crap, it is about to be a year. If this was originally scheduled in September and then moved to January, it's now July. We are 2 months away from September again. It's hard to believe that that's going to be fall of 25. Where has the time gone? But at the end of the day, yeah, I mean, they've been waiting for this hearing for 10 months now. And the prosecution is dragging their feet because the prosecution is not interested in prosecuting this case. Do you understand? They are simply using it as an intimidation tool against Aiden Carney, aka Turtleboy. That's all they're using it for. There's no real desire to lock him up. There's no real desire to prosecute him because they know they're going to lose. They know that they're not going to be successful because it is all boiling down to Aiden allegedly coming up to what? Witnesses and intimidating them? With what? How? Maybe Aiden is your non-traditional journalist. Maybe Aiden is the one that actually goes out into the field and interacts with these people for better or for worse. Maybe he's not the most traditional of journalists and his methodology is not the most subscribed to by most journalists. Does that make him a criminal? No, of course not. And that's what his defense is trying to show. And the prosecution knows this. Cosgrove knows this. He knows he's got, as we like to call in the legal world, an old dog case. It's like an old dog and it's got fleas on it and you just want to get rid of this dog. You don't want to treat it. You don't want to, this is not your friend. This is like someone else's dog. You're watching for them. It's an old dog with fleas. All you want to do is get rid of it, get it off your docket, get it off. That's Cosgrove's case. Aiden Carney is Cosgrove's old dog case with the fleas. He's just trying to get rid of it. He just doesn't know how. Because he doesn't care. He's not going to want to prosecute Aiden. It's a losing battle. It's a bad case.
The consequences, which the court, again, is probably familiar with, he was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions,
yes,
so the court can issue a decision as
yes,
to whether he's going to be allowed to continue,
yes,
or whether we can go
stop dragging your feet and do your job.
through the process of subpoenaing him and any other items.
Where's the problem?
Of assistance to us with calling him as a witness.
Mr. President.
Could I inquire if Mr. Mello is online?
I do not see him. Attorney Mello? Last time you raised his name, there's no one.
Can I approach?
Of course, come on up.
He looks so
I don't know, you
defeated.
said you had one more thing.
Yes, Judge. Just as it relates to discovery, we have made a
Sirens.
series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state
Catherine.
police and the district attorney's office.
Oh, remember? Catherine Peter is the sleeper agent that has been paid by D.A. Morrissey's office with the affidavit that was filed a few months ago, where a friend of Catherine Peters admitted that Catherine had conversations with Hank Brennan. She has had conversations with Lally. She has went to dinner with Brennan, I believe, and she has been instrumental in getting paid through like Cash App or Venmo or whatever, some back channels, Zelle. At least one $1,500 payment was made to her to act on behalf of the Commonwealth, doing all sorts of shady stuff, including in the public interest, feeding information to the public on X, if memory serves. Oh, by God, this is good.
Her very unique relationship in all matters involving Mr. Carney.
Yeah.
Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail. Her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Carney, voice recordings that she has left Mr. Carney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuri Buchanan, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Carney's case and may or may not have had a relationship with her too. She has made statements allegedly
there it is,
indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't.
Now, Betterow knows better than this. Betterow knows this is never going to happen, but he has to make a record. He has to make a request. He has to ask the judge to order the Commonwealth to do this. Now, do you honestly think D.A. Morrissey is going to go from office to office and go, okay, let's start with this prosecutor. Hey, prosecutor number whatever. Have you had any involvement with Catherine Peter? No? Okay. Next prosecutor. Hey, have you been involved with Catherine Peter? No. Okay. Next prosecutor, have you... Please. But he knows he has to make the request. Whether they do it or not is irrelevant. What's important is that the request needs to be made and an attempt by the defense to get the prosecution to do something has to be made. Period. The end.
That has happened. We respectfully submit that is something that Mr. Cosgrove has to do.
Yep.
In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Carney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real. They're obligated to do it, and we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose, and if that's the case, then we'll all live and die with the consequences of that statement.
Okay.
No, it's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go ahead.
Yes, yes. So this will be an opportunity, Your Honor, for myself and Mr. Betterow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time,
The Catherine Peter
it
affidavit.
was initially filed provisionally without hearing from the Commonwealth. Was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradle's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall fairly outrageous, if I can put it that way, representations that were made by the fiat. I believe now, as I moved at the time, that affidavit should either be stricken.
Oh, come on, you coward.
Order should be lifted. I don't believe an fiat should be allowed to accuse an assistant VA of jury tampering and district attorney.
But if they did.
Secret meetings with witnesses and all these other things, and then hide behind them.
Oh, so you can charge Aiden, but take the spotlight off of us, please. We don't like it. We don't like it. Put the spotlight back on him. This doesn't work for us. We do not like this. We like to be in control. We are control freaks. We are sociopaths. We really don't like the spotlight on us. Take it off now. Is this guy for real? I don't understand.
Okay.
What?
Yes, a couple things that I think ought to be corrected.
Yeah, you think?
Affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do, and at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement.
Yeah.
And almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay. Just make 2 points in response.
It's a very hairy situation, because think about it. On the one hand, she wants to help Aiden. On the other, she is betraying her kind. She's in a very, very precarious and dangerous situation. The informant, the author of the affidavit, which we still don't know who it is, obviously for obvious reasons, as Mark Betterow literally just explained. Let's see how this ends. I want to hear what Cosgrove has to say about that. By the way, don't forget to like this video, comment below, subscribe to the channel, hit that notification bell so you get notified when more of these videos come out.
The affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at this one point, the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet. And was all over the internet at the time it was before you the other day. I don't know what the interest is.
There's a difference between it being all over the internet in like private circles and being all over the internet publicly, bud. Do you understand that difference, Cosgrove, or no?
Circumstances.
Apparently not.
In concealing it in the court papers.
Judge, I'm sorry. I'm sorry.
I'm sorry. Go ahead. Could I just add one thing?
Yeah, go ahead.
Apparently these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time. First of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay, I see. So his argument is, Your Honor, it wasn't us, okay? It was the defendant, Aiden. Aiden is the culprit. This is what Cosgrove is arguing. Aiden is the culprit who identified who this woman is, but for Aiden's posting of the photo of calling the woman a snitch, people recognize the apartment building, they recognize the apartment, they figured out who lives there, and then they figured out who it is. So that's how it got all over the internet, is because of Aiden. And because Aiden is the one who spread the information, he is the defendant in this case, she should not be enjoying the protections and her name should be unimpounded and released to the court. It's a cute argument. I don't think it holds a lot of weight, but I see where he's coming from.
Very quickly, Your Honor, in terms of this individual's name being on the internet, there are two reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally.
Oh, wait a minute. Okay, so I take that all back. It wasn't Aiden. It was Catherine and Cosgrove. I swear they're like that Spider-Man meme. They're like, you did it. No, you did it. No, you did it. I didn't do it. You did it. No, you did it. Like, oh my God.
With no malintent is not a reason, I think, you just open up the affidavit to her name.
Okay, thank you all. So we have a date for, who was it, August? What was the date, man?
August 13th.
August 13th. And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yes,
What's the
you
end
want
of
to
the
pick it
month?
now, or do you want to pick it on the
Why don't we
13th?
pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some.
I really like this
information
judge.
about,
That's fine.
the health status at that time.
All right. We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
I'm sorry. I believe we have an agreement. Mr. Bradle has responded relative to the source code for accessing the search of the devices. And he's indicated that it was the same source code previously provided to Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
Sure,
And I
Mr.
don't think
Wood.
there's a disagreement with that.
You don't
That's
disagree
agreed
with
on.
that, do you?
Sure, yeah.
All right. I'll see you August 13th.
Thank you.
All right, take care.
All right, see you guys in August. Wow, that was fascinating. That was absolutely fascinating, folks. I was not expecting all of that, to be completely honest with you. And good on you, Aiden. I hope this case continues moving forward. Not shockingly at all, the government is moving at a snail's pace. They are dragging their feet because, again, they're not interested in justice. This is not about justice. This is a vendetta, a personal vendetta against one man and one man alone, and his name is Aiden. He is a journalist and a reporter, and like I said, maybe his methods are a little bit unorthodox and non-traditional. Who cares? He's done what he's done, and now they are prosecuting him. He served 60 days, or was it 90 days, in jail over this. Did you know that? At least 2 to 3 months, I know for a fact, he spent in jail. I interviewed him right after he got out. So go check out that video. I have a couple of Turtleboy interviews. I should probably have him back on to talk about all this. If I know it's a sensitive, ongoing case. Obviously, he's not going to be able to say too much about it. But regardless, I think there is a lot here. I'm glad that we went over it, and I'm looking forward to updating you guys on the developments of this case. I'll see you guys next time. Don't forget to like this video, comment below, subscribe to the channel, and I'll see you in the next video. Bye, everybody.